Please stand. Municipal Court for the City of Fort Collins, Colorado is now in session. Judge Kathleen M. Lane presiding. You may be seated.
And good afternoon. All right, so for the record, it is May 26th of 2016. We're here for a trial session, and we have two cases against Mr. William Kent Montgomery. And thank you for being here. All right, so we have case 2015-216213, camping on public property. I believe this is one where the failure to appear charge has been dismissed. All right, and then we have case 2015-206835, Perks Trails violation. So is the city's preference to deal with the 2015-206213 charge first?
Yes, sir.
Okay. All right, so in that case, we have a charge from September 2015, and actually the day is difficult to read on the summons.
Yeah,
Is it the 5th or the 8th?
September 8th is what the date is. But,
Is September 8th?
yes.
Okay.
So,
That's the date that's clear on the lower right hand for when it was issued, but the upper left, can't tell whether it's a 5 or an 8. So that is 0908
apologize for
15.
we're proceeding. It was September 8th was the date.
All right, so I'm going to go ahead and clarify that on the ticket. Mr. Montgomery, were you aware that that was the charge was relating to September 8th?
Yes.
Okay. So the charge is section 17-181, camping on city property, or the way we have it in the computer is camping on public property. Relates to Lee Martinez Park, it looks like, is the location that's listed. All right, and as I said, there had been a failure to appear issue. That's been resolved. That charge is dismissed. So the case was eventually rescheduled for trial for this afternoon. Mr. Montgomery, we do show that you had originally been advised of your rights on this misdemeanor case back on October 14th of 2015. So the case has been going on for some time. Do you have any questions at this point about your rights on this misdemeanor case?
No.
Okay. And the petition of indigence had been signed by me, so the costs, no potential for costs in this case. I believe, let's see here, that this is a case where we had court-appointed counsel at one point, and then defendant requested that you wanted the attorney to resign and represent yourself. Am I remembering that correctly?
I'm not sure if that was the constructing a structure case, but one of them is happy to continue. Proceed at all.
Okay, so at this point, we had you review again today the questions relating to right to counsel to make sure that as of today you are comfortable representing yourself, understand the risks that you take by representing yourself, and that you do in fact want to waive your right to have an attorney. So is that correct?
That is correct.
All right, so I'll consider that to be a voluntary, knowing, intentional waiver of right to counsel. So then, are you ready to proceed to trial?
Very on me.
Correct. Is the city ready?
Yes, Your Honor.
Okay, you can go ahead and call your first
Your Honor,
witness.
call my questions in.
Give me one moment. All right, raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, go ahead and have a seat. Go ahead.
Good afternoon. Can you please state your name and spell your last name for the record?
Michael West, W-E-S-T.
And what is your current occupation?
I'm a park ranger for the City of Fort Collins Parks Department.
And how long have you been employed in that capacity?
Just a little over 2 years.
Prior to that, what was your occupation?
I was a police officer for the City of Fort Collins for 26 years.
And were you working as a parks ranger in the morning of September 8th, 2015?
Yes, sir.
And what were you doing at approximately 9:34 that morning?
I was on foot patrol in the area of Lee Martinez Park, 600 North Sherwood. walking in a wooded area west of or east of the East baseball field. They're in Lena Martinez Park.
Is that located in the city of Fort Collins, state of Colorado?
Yes.
And what did you observe as you were patrolling that area?
Walked into the woods and saw at least two people who were laying in an island area of the woods on blow-up mattresses with sleeping bags and blankets, and had two bicycles next to a tree in there, and they were sleeping.
So what did you do at that time?
Went ahead and contacted Fort Collins Police Services and asked for a cover officer while I made contact with them.
Okay. Do you recall approximately how long it took for the cover officer to arrive?
It was fairly quick, within maybe 5 to 10 minutes.
And did anything change with the two gentlemen that were, well, you didn't know who they were at that point because you were covered up, but the people that were on the air mattresses?
No, they were still sleeping or under their bedding.
And so once backup arrived, who arrived?
Officer Wes Haynes, Fort Collins Police, and then Natural Area Park Ranger Rhonda Peckham.
What did you do once you had the backup arrived?
Went further into the woods, identified ourselves as park rangers, police officers, and asked the people to come out to us, just a walk about 20 feet towards us, just away from the camp.
And so did the two people that were there approach you?
Yeah, they got up out of their beds and came over to us, and I ended up talking to David Montgomery.
And the two people identified themselves?
Yes, they had a driver's license or IDs.
And you indicated that you issued a summons and had contact with David Montgomery.
Yes, sir.
Who was the other person that was?
William Montgomery.
Is he here in the courtroom today?
Yes, sir.
Can you please identify him for the record?
Yes, sir. He's sitting right here.
You know, let the record reflect he's identified the defendant
Well,
as one of the people that he contacted. Did you take any photos that day?
Yes, I did.
I'm going to show you what's been marked as People's Exhibits, City Exhibits 1 through 4. May I have first witness?
yes.
Did you see these four? I think that was part of my discovery. Oh, okay. Where is
If you want to look at it again.
If-
It's been a
yeah,
while. I
which
mean,
one?
obviously, the discovery was provided a long time ago, so.
So when somebody gets a discovery, they order just through the front office. That's what I did. I only got a police report. I never got it. I've never seen these before.
Front office of the city attorney's office, is that what you're talking about?
Yeah, I believe so.
Okay.
I recall
Your Honor,
giving me police
he's been
reports.
to our office several times, and we've supplied him with all of the discovery in all of his cases.
I can guarantee you, if I had seen these, I would have been able to prepare some questioning on them. I guarantee you, I have not seen them before. If I had access or I've been able to know about them. I don't know. All I know is that my discoveries, they were printed police reports that were full color.
So do you have documentation about when you believe that photographs were given to the defendant?
Well, I have documentation about when the discovery was provided to the defense counsel, but I'm not sure. I don't have that documentation with me. Part of the thing is we've got several different files. I mean, the Montgomery brothers have been to our office several times requesting all of the discovery on these cases.
Right. But the question now is, do you have any notes to indicate what date your office may have given
I don't,
photographs?
at this point, because I don't have the complete files, because this case has been going on so long. So it's probably, just would have to try to find it in the office as far as the documentation of when the discovery went out.
So if we give a few-minute recess. The defendant can look at the photographs, and you try to find some documentation about whether they were given to the defense counsel that was on board for a short time in this case, or to the defendant directly. Find some indication, since he's indicating that he has never seen
Well,
them.
if we want to take a recess,
Let's go take a short recess, and meanwhile, we'll let you take a look at those. If you want photocopies of those, I think we can make color copies. We can't make color copies, okay. So hopefully looking at those, sharing them will work. We'll be in recess for a short time. Can I just stay there or have a seat?
And Municipal Court for the City of Fort Collins, Colorado, back in session. Judge Kathleen M. Lane presiding. May be seated.
All right, so we're back in session. And Mr. Fink, what did you find out about
Well, we
the
tried to
discovery
track
issue?
down things. Part of the things with the length of time, discovery looks like was provided in October of 2015 to the defense counsel at that time. In the meantime, I think the defendants, I think, have been given discovery too. It's just I don't know if they requested. I'm speculating on this that they requested discovery after the attorneys. Again, I'm not sure. After they fired the attorney, what they indicated that they have provided discovery to both David and William had come to the office and provided discovery. I don't have specific dates about that, and I can't represent. In this case, couldn't come up with documentation exactly what discovery was done. The attorneys.
Kenneth Barker
From
had
that.
entered an appearance and requested discovery on October 16th of 2015.
Right, and so that's part of the problem. These things is that our emails type of things that we've got a 90-day retention schedule, and so this stuff was coming back in October. So she's looking for documentation,
But your understanding and notes indicate that the defense attorney was provided with discovery shortly after he entered, so
well,
sometime
he was
that
provided
month.
with discovery, and I think at that point, what they've told me is that the Montgomerys came in, both of them together, David and William, and that they provided discovery to them. But I don't
Individually as
know
well.
if that was before. And I'm trying to, because I don't have the court file. Court file, I think at this point, I don't know if they were representing themselves first and requested discovery, or if they went in and represented discovery after the attorneys were relieved.
We show that court-appointed counsel was requested and set up starting October 7th, 2015, after the first pretrial.
Okay.
And so by October 16th, we have Mr. Barker's entry as the court-appointed counsel, motion to set for a pretrial, and the request for the discovery. All right. Well, given the circumstances and the indication that there was discovery given to the attorney, and there's in his motion to withdraw, he indicates there was a pretrial conference. There isn't any indication on that about lack of discovery. That was filed November 8th. If the discovery was provided to the attorney, it would be considered as being provided to the client as well. How much information was transferred is something only the defendant would be aware of. But at this point, since there are photographs that indicate or back up in descriptive way what the officer's indicating, correct?
Yes.
I'm going to go ahead and allow them, even understanding, Mr. Montgomery, that your statement is that you have not seen those photographs before. It sounds like the city attorney's office intention was to get you all the discovery they thought they had, and so are surprised that you're indicating you hadn't seen
And to
them.
be honest with you, it didn't come up at David's trial.
So
I
I'm
mean,
gonna-
that doesn't mean,
Okay.
I'm certainly not saying whether Williams saw them or not.
So how many photographs are
There
there?
are 4 of them.
And you have them labeled cities
Yes.
1 through 4? Okay, so I am going to go ahead and allow you to at least begin to attempt to use them at this point.
So if I may approach the witness, Your
Yes.
Honor. Your Honor, Officer, I've handed you what's been marked exhibits, city exhibits 1 through 4. And can you please individually identify what each of those exhibits are for the record?
Yes. Exhibit number 1 has part of the bicycle, one of the bicycles in the photo. and then has photos of the 2 beds that the brothers were sleeping on. One is with a blue tarp underneath it and a kind of a grayish blow-up mattress. And then one of the brothers underneath a kind of a grayish blanket. And then back behind him is another bed, and one of them in a red sleeping bag. Exhibit number 2 is pretty much the same thing, just not near the quality, and a little further out where it shows both bicycles in the photograph. Exhibit 3, I believe, is when one of them is starting to get up out of bed, but I can't tell which one that is. And then,
It's parked in the back, sorry.
yeah, Exhibit 4 is a photograph of the bikes, and one of the bikes being chained to a tree in there.
And who took those photographs?
I did.
And when did you take those photographs?
I took probably all of them, except maybe the one where looks like the person's kind of waking up or getting out of bed prior to Officer Haynes getting there. So I walk in, I take a couple pictures, walk out, and then ask for police assistance. And then I believe that one photograph is when they're starting to get out of bed after we've identified ourselves.
Okay. So you took 3 of the photos earlier, and then 1 photo you took after, a little bit later when Officer Haynes. And are those true and accurate depictions of what you were observing then?
Yes, sir.
You know, I'd ask to enter into evidence exhibits 1 through 4.
Okay, so Mr. Montgomery, objection to the photographs at this point?
I just have a little concern about the 4th one being a different time frame. Was that the same day?
Yes, sir. Yeah.
Do you have a time?
I do not. No.
Oh, okay.
It just looks like one of you are starting to get up, but the quality is not very good.
So which ones were the ones taken first?
Oh,
I mean, before officers arrived. Yes.
yeah. So I would say Exhibit 1, 2, and 4 are prior to Officer Haynes' arrival, and then probably the Exhibit 3 is when we identified you started to get out of the beds.
Before contacting us. Okay, no objections.
Okay, then I will admit those 4 exhibits.
If we could have a bailiff, they were, go ahead, show us.
All right, go ahead with your questions.
You issued a citation in this case, I guess, accurate and more accurate. Each of you issued a citation to one of the defendants.
Yes, sir.
You've testified that you issued David Montgomery the citation.
Yes, sir.
And Officer Haynes issued William the citation. And what were the citations for? Or do you know other than just your citation?
No, they were both for camping in the city where prohibited, 17-181.
All right, thank you. I don't have any further questions.
Okay. All right, so Mr. Montgomery, this is your opportunity to ask questions you have of Ranger West.
Is there a separate unattached pen I can work with?
The separate unattached pen, did you say?
Just for the record, going over David's transcript, I believe there were 4 pictures that were also entered in his case. Do you recall if these are the same 4 pictures entered here today?
Yes, sir, I believe so.
Okay. So, what constitutes, or how do you define when and how to exercise discretion? Presuming that it's part of your job that you're able to do.
I have the ability to use discretion each and every day, dependent upon circumstances. And I factor in prior contact, the circumstances, the physical evidence in front of me, the totality of the circumstances, just sort of the big picture. There's a multitude of things to have discretion about, I guess, sir.
Okay. Are there occasions where you have exercised discretion and caught somebody camping and then decided not to take it up?
Not to what, sir?
Not to take it up.
Oh, take it down. Sure.
So in my particular situation, or between my brother and I don't know if you worked with Wes Haynes to look at my record versus his, but were you aware of any sort of prior tickets of any sort of nature that would lead you more to ticketing rather than warning?
No, sir. I didn't know who I was contacting that morning until you all got out of bed and came to talk to us.
Okay. So at what point did you?
I'm sorry, just a second. Would you repeat that answer?
I did not know who I was contacting that morning until Mr. Montgomery that got out of their bed and came and talked to us.
Go ahead.
So, at what point did you have probable cause to issue a citation for the camping statute? What did that probable cause conceptualize in your mind?
When I walked into that, I call it kind of an island, but when I walked into the woods and saw two people on beds in the woods, on blow-up air mattresses, under blankets and sleeping bags, to me that is camping with the bicycles locked up right there. That's when I knew
So,
the probable cause.
Is it possible for people to use blow-up air mattresses to incidentally nap?
Highly unusual. It's possible, yes.
Possible. Okay. It's also, I presume, possible, correct me if I'm wrong, to want to lock up one's bike while one's incidentally napping?
It's possible.
Possible, okay. So, could you help better define the difference between incidental napping and camping in terms of your experiences with ticketing people?
Yeah, I would object. It's common for the officer to make a legal conclusion, which I think is the court's job in this case rather than the officer.
And how, if the officer were to answer your question, how would that be relevant to your case?
Well, I'm going to claim that without knowing if we were incidentally napping versus camping, and the possibility being existent that we could be incidentally napping, I don't believe that Ranger West had any probable cause to contact us. At most, he would have to start off with reasonable suspicion and then gather information from there. And so I would motion to suppress anything after that, basically. No probable cause.
Let me pull up this.
I imagine the first step in an investigation is to help narrow down and identify, confirm or dispel your suspicions, and without any information from observation alone, it sounds like that you could have started with reasonable suspicion, but because they started off with probable cause, one of the elements of camping is that I'm not incidentally napping, maybe with a lack of address, or if you ask me questions, I can answer a certain one. Basically, without any of that information coming from me firsthand, you basically stopped us without any probable cause.
All right, so let me take a moment here. Let me go ahead and read the code section we're dealing with at this point. 17-181 says it shall be unlawful for any person to camp or pitch a tent or knowingly permit any person to camp or pitch a tent on public property within the city. Camping, for the purposes of this section, shall mean to sleep, spend the night, reside, or dwell temporarily with or without bedding or other camping gear, and with or without shelter, or to conduct activities of daily living, such as eating or sleeping, in such place, unless such person is camping in compliance with Chapter 23 in a natural or recreation area. Camping shall not include incidental napping or picnicking. And Mr. Fink, am I correct that the code does not have a definition for incidental napping or for picnicking for either of those?
That is correct. I'm not aware of any separate definition from those.
Okay. So city's position is that it's a factual question in terms of whether the evidence presented proves that charge, and that the defendant's asking the ultimate question that the officer...
Well, I think basically what I think really what it comes down to is it's going to be up to the court to decide if the defense is that he was incidentally napping rather than camping. That's a determination, a legal determination for the judge. I don't believe it's appropriate in this case to argue that the officer did not have probable cause to cite him for camping.
Okay. So, Mr. Montgomery, what I'll allow you to do is ask the question of, based on how that code section is worded, what were the officer's observations that led him to believe that you were camping as opposed to incidental napping? Does the city have an objection to that question?
No, that just...
Okay. So I'll let you go ahead and ask that, which is a little different format, but similar to what you'd asked.
Sure, and I'll actually start with this. What time approximately would you say that you first contacted or first saw us, my brother and I?
Maybe like 9:20.
And I presume Lee Martinez Park hours are sunset to sunrise, is that correct?
11 p.m. to 5 a.m.
Okay, so we're definitely in the park after that, or when you found us. When did you contact us with West Haines in Roundup?
Around 9:30 a.m., 9:34, right in there. Took them about 10 minutes to
So only 10
get there.
Okay, so before then, you had not been able to see or determine at what point I may have started sleeping, or that David and I may have started sleeping.
No, sir.
There's no indication of when that could have started. Okay. So the only thing we really know for sure is that people were sleeping for a total of 10, 15 minutes. Based on that, or going back, how did you, could you possibly elaborate on how you determined that we were no longer incidentally napping before contacting us?
In my experience, people who come into the park and incidentally nap may take a blanket or something and lay out in the open areas of the park, and do not bring a bunch of belongings in there. They're there for a short period of time, then they get up and they move on. In my observations of you, Mr. Montgomery, and your brother, there was a lot of equipment in there that I've testified to, with mattresses, blankets, sleeping bags, tarps, and bicycles being locked up. And people that incidentally nap normally do not go into isolated areas. They're out in the open, in the sun, getting sun and staying warm.
But it's possible to incidentally nap in the shade, too, if they're looking for shade.
Yes, sir.
Okay, so that's true, too. But it was sort of, it sounds like you were basing your probable cause off of your experiences, the information that had led you to believe that it had to have been camping versus could have been incidentally napping.
I think I said that I believe you were camping, yes, sir.
Okay. So, the camping statute, the opposite of incidental napping. Let's presume that, for argument's sake, that sleep and incidental napping are mutually exclusive. So that would mean, correct me if I'm wrong, does the sleep side of the camping statute indicate something along the lines of habitation in terms of defining it versus an incidental napping as somebody that's not using it for the purposes of habitating?
I'm not following you, sir. I'm sorry.
If you were to better define the camping statute as ticketing people for habitation purposes versus non-habitation purposes, do you believe that this statute is tailored to address habitation?
This is not I don't define ordinances. I just enforce.
Okay, let's see here. So, was there any damage that it looked like to the quote-unquote campsite that you were able to see at all?
Your camp remained there for several days, and once you left, I did find that the vegetation had been laid down. As far as damage, other than just smashing grass, and I did not see any permanent damage.
Okay, so you said you had found us later. You said that we had been there the whole time. It's possible, though, that you could have found us on a new occasion, on that new time, not related to this time.
Highly improbable, based upon my observations. The next couple days, I observed your camp in the exact same manner it was the day that I wrote you the citation, or wrote your brother's citation. Nothing had been moved, nothing had been, it looked like it. The only thing is you did add a blue tarp over one of your sleeping arrangements within that next couple days.
Okay. But you never actually came back, say, within an 8-hour or 12-hour period to see if we were still there throughout the afternoons and evenings of each day. You just came back a couple days later and saw that it was all the same. Okay.
Yes, sir.
So there's a completely, entirely possible scenario that we could have packed up our stuff every day, decided to come back to the same spot because it was nice, convenient, but that it was not what you would consider creating a permanent encampment.
It's possible.
Absolutely possible, okay. There was no tents of any sort for protection from the elements?
Yes, you had put a blue tarp hung up over the trees within that next couple days.
Objection to the entry of that. I think we're just trying to get back to today's
So your
occasion.
question is on September
Just today,
8th, wasn't
for
it?
today.
Oh, sorry, yeah. On that day, I did not see any type of tarp hanging in the trees.
Okay. Let's see here. So, at the end of the encounter, did you tell us to move along?
Well, we wrote you tickets that you could not camp in city parks and property, and normally I end each conversation with you need to pack up and move on.
Okay, okay. Let's see here. Are you, do you understand any, if there's any affiliation with the city when it comes to the Murphy Center homeless shelters? In terms of camping versus do you know of services that are available to people that you would deem camping?
I'm not following you. If you ask me maybe a different way, I could understand
Yeah.
what you're asking.
Are you aware of any shelters in the city?
Yes, sir.
Yes. Do you check any sort of shelter bed counts? Did you check any shelter bed counts the night or the morning, the day you took
You know,
care
I
of it?
haven't objected. I'm not sure what the relevance of whether the shelter, any shelter counts on this. Since it's not a portion of the statute itself, I'm not sure what the relevance is.
Relevance?
Well, obviously, some things are going to turn into an appeal if I can't bring them up here in the current courts. Of course, we're going off of the jury instructions or instructions for camping, but of course, Boise, Idaho statement of interest from the Supreme Court ruling camping bans is unconstitutional when shelter beds are not adequate. I wanted to put that in there.
Well, Your Honor, if the defendant's argument is that he was not camping and that he was incidentally napping, then I don't see where the relevance, if that's what his argument is, what the relevance of whether shelter beds were available has any relevance. That's what his defense is that he was incidentally napping.
Mr. Montgomery?
I am actually saying that if I were to be considered not camping, it would be a defense towards incidental napping. But if I am considered to be not incidentally napping, then it would be defending toward camping.
I'll allow a brief inquiry. So I'll allow your question of whether the ranger checked to see whether shelter beds were available that morning. Is that your question?
Yes, basically.
No, sir.
Okay. So you had issued David a ticket. Wes Haynes had issued me a ticket.
Yes, sir.
Was there at any point in time you guys being unable to issue us tickets?
I don't understand what you're asking me, sir.
The issues, the tickets were issued without any issue. It's a bad question. Strike it. Don't even worry about it. Let's see here. So I think it was mentioned that Rhonda was with you. Was she there the whole time, or did she leave early or later?
She was there for most of it. At one point, additional officers were requested, and so she walked out of that island area to try to help the officers, find us. So she was gone for a period of time, and then she came back in
Okay.
to the woods.
So she came back in, and then when everyone was done ticketing us, you guys all just kind of left together, I presume, or?
Yes, sir, that's the way I remember it.
Okay. This being Lee Martinez Park, are you aware of any close amenities like a bathroom within walking distance?
Yes, sir.
Okay. No further questions?
All right, thank you. Any redirect?
No, Your Honor.
All right, thank you. You can step down. Next witness.
Call Officer Haynes to stand.
Raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
All right, have a seat.
Good afternoon. Can you please state your name and spell your last name for the record?
First name's Wesley, last name's Haynes, Haynes.
What is your current occupation?
I'm employed by the City of Fort Collins Police Services.
How long have you been employed in that capacity?
36 years,
And what's your current assignment?
Patrol Division.
And was that the assignment that you had on September 8th of 2015?
Yes, it was.
Okay. And did you receive a call from, was the dispatcher a call regarding request for assistance from Officer West?
Yes, we did.
And were you in that general area?
Yes, I got assigned the call.
And so what did you do when you got assigned the call?
It comes across the mobile laptop that he found a camp and didn't know how many people were inside of it, and was requesting a uniformed city officer to assist him in contacting the occupants if there was occupants there.
And is your experience, is that common to request backup?
Yes, it is. The Rangers are not armed, and police officers are.
So most cases, probably they are going to request backup.
When the situation, they feel uncomfortable about it.
And so when did you get there?
I'd have to look at the CAD notes of when the call came in, when it was assigned, when I went en route, and when I went on scene.
Right. And obviously, without the CAD notes, you probably wouldn't recall how long it took you to get there.
Yeah, 5 or 10 minutes.
That's really what we...
It's my normal working area.
Okay, great. When you arrived at the area, what did you observe?
Ranger West briefed me that he found a camp that was back in the woods, kind of secluded, and wanted to contact the occupants, if there were any occupants there, and just wanted a uniformed presence officer with him.
And what did you observe at that time?
We walked in from where our cars were at, and there's a couple of air mattresses out, some sleeping bags, some blankets, and what kind of appeared to be, a bump in the sleeping bags and mattresses that would indicate to me that there was somebody there.
And so did you then call out to the people in the air mattresses?
Yeah, we identify ourselves as the park rangers and the Fort Collins Police.
And in fact, were there two people in one in each of the air mattresses?
Yeah, after we called out, that you could see people moving around, kind of slowly getting up, and then, we were making eye contact with them, they were making eye contact with us. We asked them to come out to us.
And so who came out from the sleeping bags and the air mattresses?
Two individuals that were later identified as William and David Montgomery.
Who did you have contact with primarily?
I had contact with William.
And so what happened when you contacted him?
Advised him that, in our opinion, that they were camping in the Lee Martinez Park, and we were going to issue them summonses for camping.
And what happened after that?
Filled out the summons, explained to him, told me he was not going to sign. I refused to sign there, tore out the pink copy and gave it to him, and we left the area.
What kind of conversations were going on? What was William telling you when this was going on?
It was a long time ago. There was a lot of conversations, and I didn't document any of it.
All right, I don't have any further questions.
All right, Mr. Montgomery, this is your opportunity to cross-examine.
So your experience with West Haines, could you elaborate on how you determined that we were camping versus incidental napping based on your observation before you contacted us?
My experience over 36 years, the incidental napping is somebody's laying out in the sun, in the shade, on a blanket, and then come back by later on and they're either gone, they're sitting up, where this was, in my opinion, with the air mattresses and the blankets and the tarps and the hour of the day, it was, to me, camping.
Okay, so kind of basing on my previous conversation, would you be comfortable with using the word habitation as a way to determine the difference between camping and incidental napping?
You're going to have to give me your definition of habitation.
Using it for the purposes of survival, one has to sleep at least 8 hours a day, or some sleep throughout the day, versus an incidental napper who may have a home to sleep in. And this is just a nap that's not done for the purposes of habitation or survival.
I think the question is the same.
Okay.
Because incidental napping can be at home, can be in a park, it could be in a parking lot, park bench, sidewalk bench, somebody's porch. So to me, they're the same.
Okay. Would you say that the tendency of those who get issued camping tickets are that they are homeless?
Yes.
There's quite a tendency. Okay, so that's kind of what I'm trying to get at, is that it's more likely that somebody who is issued a camping ticket is homeless versus someone who is maybe getting an incidental napping ticket. It's probably not, as in your experience, been as homeless.
We don't give incidental napkin tickets.
Oh, I see. Of course, that makes sense. But have you, in your experience, have you ever issued an incidental? Have you ever issued a camping ticket where they claimed that they were incidentally napping?
Yes.
Of course, some boilerplate stuff anyway. You arrived at the scene approximately 9:30 or so?
Something like that, yes.
And you had personally witnessed us sleeping for only a couple minutes before you woke us up?
That is correct.
Okay. Would you consider it possible that we could have been incidentally napping?
Well, anything's possible.
Of course. Did you ever ask us or ask me if we were camping versus incidentally napping?
I do not believe so.
Okay, so you can ask us. Did you happen to check any shelter beds that previous night yourself? The two available shelters to see if there were...
We're not required to.
Not required to. Do you recall telling me to move along at the end?
I'm sorry, repeat that?
Do you recall telling me to move along at the end of our ticket procedure?
I could have. It seemed very possible. It's after the summonses in my past have been issued for that particular, tell them to have to pack up, give them an amount of time to gather their belongings and move along. But it was not documented by me.
Did you, or if you recall, anybody else, did anybody else come by later on that day to see if we were still there?
Not to my knowledge.
Okay, no there. And Rhonda, she was there. She was recording the whole time. Is that...
I did not know that till the end.
Oh, okay. But did she leave with you guys? I know she kind of stepped down a moment, but...
We arrived, I think she arrived a few moments after us, walked in. She knew that we had requested a couple more officers and that she was going to go back out to where our cars were. So when those officers arrived at our cars, that she could walk them back into this area. It was September. The foliage was still on the trees and the bushes, so could not see it from where our cars were at.
Okay, so she did request backup, but you guys canceled it. Sounds like she came back in and was there watching you guys as a witness toward the end.
That she canceled the backup?
Or not she, but yeah, not that she canceled the backup, but the backup was canceled. Too many questions.
Okay.
Sorry. When she was done talking with the officers, did she come back and continue to witness the event?
She went out, got the officers, came back in, and then my next recollection of being with her is back out where all our cars were.
Okay, so would you say that you, Mike West, and her all left at the same time, and you were all done with us?
Yes.
Okay. Could you possibly describe why we deserve a camping ticket versus possibly a warning? The discretion.
It's just a discretionary call. Made the decision that based on the way it was set up. We seen. We didn't know who was in the bedrolls, either sleep bags or blankets, that we were going to issue them, and then you came out.
Okay. So without even knowing if we even had prior tickets, it sounds like you already decided camping when you saw us.
That's right.
Okay. Real quick, I think we talked briefly about other places that are accessible in the city to sleep. Was the KOA mentioned? Did we talk about that?
We talked about the KOA. I can't remember if it was this contact or a previous contact or contact afterwards with you. That KOA was mentioned, and there was something about it was too expensive. And too expensive or too far out.
Okay. Are you aware of any other places to conduct sleep for the purposes of long-term habitation that do not involve the shelters within the city limits of Fort Collins?
Not to my knowledge, none.
Have people in the past requested what to do when the shelter beds are full? And what sort of answer have you given them, if possible?
Up until recently, we did not know what the status of the shelter beds status was. Here in the last cold weather, I believe the shelters have called the police department when they close off their admittance and saying if they have availability or not. But before that, they never called us and we never called them.
Okay. So there's no agreement to suspend ticketing when the shelter beds are full that you're aware of?
Back then, no. Now, I don't know.
Okay, no worries.
All right, thank you. Any redirect?
No, Your Honor.
All right, thank you. You can step down. Next witness. All right. Then, Mr. Montgomery, this is your opportunity to present evidence if you choose to do so. You have no obligation to do that. The burden is on the prosecution to prove the case beyond a reasonable doubt. You do personally have the right to testify and not testify. We had you take a look at a series of questions on those rights as well. Did you have any questions about your rights to testify and not testify?
No, Your Honor.
No? Okay. And knowing and understanding your rights to testify and not testify, what is your decision in this case?
I'll testify.
Okay. And so that decision is being made voluntarily and without pressure or coercion from anyone, is that correct?
Yes.
Okay. All right, so when you're ready, if you'd come up to the witness box, and you're welcome to take any notes with you.
May I request a short recess?
Yeah, just a few minutes to prepare?
Yeah.
Okay, we'll have about 5 minutes and then come back. Recess.
Please stand. Municipal Court for the City of Fort Collins, Colorado is back in session. Judge Kathleen M. Lane presiding. You may be seated.
All All right, so we'll be back in session for the trial, and Mr. Montgomery, I think you were about to testify. Did you still wish to do that?
Give me 30 more seconds. Just one last question. So, oh, go ahead. That's right.
Okay. Welcome to take notes with you. Get over the witness box, we'll swear you in.
Yeah, before we get started on that, Officer West has a doctor's appointment coming up, and so I don't, guess we could ask the defendant, but I guess one of my questions is whether we can release him from the subpoena.
Okay. Did you need Officer Ranger West to stay for possible testifying your portion of the case, or are you comfortable with him being released? Okay. All right, you're free to go. Thank you.
Thank you.
All right, Mr. Montgomery, go ahead and raise your right hand there. Do you swear or affirm under penalty of perjury that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead and have a seat. Start first by stating your full name, spelling your last name for the record, please.
My name is William Kent Montgomery, Montgomery.
Okay, and go ahead with your testimony.
Okay. Hi guys, how's it going? I think we have a little problem in our city that needs to be dealt with. And who better than Bob and me? No, I'm just kidding. Well, yeah, boy, where do we start? Born and raised in this town. And I'll try and keep it brief. It's all relevant, by the way, 100%. Every variable I mentioned. So I'm not just trailing off, I promise. But yeah, so, born and raised in this town. Mormon family moved here from Utah. Basically, I follow away from my Mormon family with all this nice information we have access to. My brother falls away too, so we kind of become estranged lost boys, Mormon boys and so forth. And so, basically, in a nutshell, I had a developmental disability of kleptomania as a kid that went unresolved, unchecked, undiagnosed, undiscovered. My parents didn't punish me for it when they did find out about it, and so on. In a nutshell, Bob, again, I know what you're getting at.
I guess I'm not really sure how this is relevant. I mean, I want to give him a little bit of latitude, but on the other hand,
I'll speed it up. I'll speed it up.
You can quickly relate it to the separate.
Well, in a nutshell, I get in trouble with the legal system, and I'm trying to get on my feet, and I end up being wrongfully convicted. I find out 4 years later. I tell my brother about it. He's my only witness. He ends up going downhill through a defamation case against my parents. Neither him or I are getting any help for the next several years as we're trying to find jobs and places and legal help and medical help. And so eventually the city comes along, tries to fine us $141,000 for allegedly breaking the 300-letter rule, and while we're putting that together, we get assaulted out of our residence, and that's how we ended up homeless. So there's legitimate places and times and things that can happen that cause people to be homeless through no volition of their own, no choice. Believe me, we try. And so while we were homeless for the first couple of months, but by the way, throughout the last 12 years from that time that I was wrongfully convicted, about 12 years ago, I had already fallen into homelessness about 5 or 6 years in. So about 6 years ago, I already had it all happen to me. Lost my job, lost my place, everything. Had to start over from scratch at the bottom. I tried the shelters. I was kicked out of one for working too late when I was actually given permission to. They just kind of grew tired of that. So that was the open door mission, so announced open door. And then I got to the Catholic Charities. They basically...
I'm fine. It just would be helpful for me if when he's talking about this, we can have a time frame.
Sure. Yeah, absolutely.
If you don't mind.
Yeah. So like
not approximately, I don't mean like
months and stuff. So basically last April is when we were assaulted out of our residence. By last July or so, we were kind of done putting our complaint together of the 300-letter rule. rewinding real quick, the first homeless stint that I experienced was about 5 years ago, just falling down. The reason I mention this real quick is because I tried both shelters. Like I said, I was kicked out of one for doing nothing wrong but working when told to. And then the other was Catholic Charities. I had stayed there the full time, but they had released me after 3 months saying that I couldn't stay there anymore. And so I tried getting back into the, I ended up staying at a friend's house. My dad loaned some money to me. I got back up to my feet. But lo and behold, to lose the job and place all at the same time again. And so now this is spring of last year, April. David and I, by about summer, we're basically trying to find places to sleep while retaining our due process rights to put together our counter complaint and our motions to dismiss for this big case, the Municipal Court 3 Literal. And basically what happens is, how do I put this? Let me word this right. We actually end up trying the shelters again because it was so desperate out there. And it was cold and wet, and I initially had not chosen to try the shelters when we became homeless this last time because of how it didn't work with the previous shelters. Also, by the way, that previous time, 6 years ago, I was harassed by people for having different views, and also I got bed bugs. And also, I'll admit, I broke into my storage unit every day to sleep for 3 hours from 6 to 9 because the shelter only provided about 5 hours of actual sleep each night. And, trying to work off of 5 hours, that's pretty possible. So, but anyways, fast forward back to the future, we took those factors and decided that we weren't going to initially try to use the shelters because of the harassment, long-term issues, so forth. We eventually, after trial and tribulation, didn't really feel like we had a choice. We actually tried to go use the shelters again. And so this was about June or July. We tried a couple of nights. Got very, very little sleep. One guy had a broken leg. He was wheezing the entire night, so I feel really bad for him, but nobody could sleep. From there, I actually got harassed a couple of days later from somebody that was staying at the shelter with me in the lunch line at the shelter. And basically I was mopping, or he was mopping, I was filling the water bottle. He really didn't like me. So basically that kind of factored into why I couldn't use the shelters anymore. We tried, we weren't getting enough sleep, and it was back to the same old harassment, and also it's a private entity, and we're not Catholic, and so we don't feel like supporting that. So lo and behold, I just want to get to the point, which is we've tried the shelters, both of them, and they're not adequate. They, for any sort of real problems. I mean, I'm sure there's some vanilla homeless people that can probably get in and so forth. But just in a nutshell, yeah, we've noticed that the city's fat and happy with where it has its camping bans versus its non-affiliation with shelters. They like to use the stats of the shelter beds if they are available. They don't like to use them when they're not available, so forth and so on. But leading up to this event here with Mike West, it's kind of a strange argument. David and I, to make sure we didn't break any sort of park curfew rules that we had learned about, as well as any constructing structure with potential tents. We slept with as little as we could, and we would pack in our stuff during the day, so not to break the 3-related rule or the park curfew rule. So yes, I will completely and totally admit that I'm using my parks and or open spaces to habitate, to sleep, so that I can get back on my feet, to get back into the rental units and so forth. So it's not the type of habitation that I think the camping ban is geared toward of vagrants or transients, passers-by that aren't interested in integrating with society. But basically, the very interesting thing about this whole situation that I wanted to bring up, the reason why I'm okay with admitting that I was attempting to quote-unquote habitate, was because I was interrupted. And, if I recall, I had shown up that morning after sunrise, probably 7 or 8, and by the time they woke us up, I was 2 hours into my sleep. So if you want to draw a line at incidental napping, I would say I never got a chance to actually habitate in the first place. Never got to. So you basically did, actually, effectively, legally, in my mind, turned that incident into a nap because I had to go elsewhere after being told to move along and wanting to respect that. Go find my actual sleep for the day. So, in my opinion, I did not habitate for the purposes of the camping ban. I attempted to, and it's very easy. Learning about probable cause, cops don't seem to think they need to use it, or they think they have it. But in my opinion, in my experience, one of the elements of camping is that you know that they're habitating versus incidentally napping, or versus not habitating. I got to allude to that. But basically, before you actually talk to us, if you don't ask us a question of are we incidentally napping or camping, you're kind of hoping for the best. But basically, the element of what you get from us, whether we're incidentally napping or we're camping, is information that you didn't have access to when you looked at us before you stopped us. And when you looked at us, all you saw were two elements. You saw a person, and a person was sleeping. And so, technically, if you had woken us up, chances are we might have even answered your questions in that way. Yeah, we're camping, or we're sleeping, this and that. Or, I might have had the argument, no, hey, I'm just instantly napping. You woke me after 2 hours. But, since you never started off on that foot with reasonable suspicion, you never had any real legal right to detain me off of a probable cause that was, at its inception, not legal. And so, fast forward a little bit, I have to just throw this out there real quick. Mathematically, it's impossible for the number of people that are homeless to leave town every night that can't get into the shelters. And so I have, some exhibits and so forth I'll present during my defense as to beds, whatever. What I'm trying to get at is you guys look at me as guilty of camping. I'm guilty. Do you know what I'm guilty of? Trying to stay in your town to get back on my feet. If I go somewhere else and try to get on my feet there, it's the same thing. I'm sleeping. Somebody's got to sleep somewhere, sometime in their lives. And when you put together the 3 unrelated rule, you can't camp in someone's backyard for more than 7 days, 14 continually, you can't park your vehicle and camp in it, kind of like bended 2 rules there, as well as what we call sleeping tickets, so camping tickets, park curfew tickets, construction and structure tickets, anything that you feel like fits to get them to, get out of town. Basically, Dave and I have already gone over this many times, it's human trafficking. You're trying to get rid of people that aren't willing to or wanting to integrate into your society and so forth and so on. But the whole point is that, I, William Montgomery, am admitting to camping almost every single night of my life. And the last year, I have camped with my brother every single night. We don't prepare food. We don't permanently habitate. We pick up our stuff if we're on bikes. We don't prepare fires. The only thing left is sleep, and we don't even have the elements to protect us from. But constructing structure, we found out, is not even a legitimate charge, so maybe we can use tents again. But let me finish on this note. My personal testimony is that if there's some sort of special agency tribunal, or maybe this is just like a one-off, or we're hoping that William doesn't incur more of these tickets in the next year and so forth. I'm going to be violating it tonight in my van. Dave and I you're going to have to find us camping, because that's how we do it. We camp, we sleep. And so, fortunately, now we're in a really neat bureaucratic point. We're able to be in our vans with our windows blocked out, and we actually had Broomfield Police Jimmy in on us one day, and we're like, do you have a warrant? And they're like, no. Are we free to go? Yes. So, I'm just trying to get to the point, which is, I'm guilty of sleeping. You got me. Oh, man. Kind of looks like a black ticket. It's not fair. It's hugely intellectually dishonest. Dave and I have more stats than we've ever even wanted of how many truly people are on the streets underneath at the bridges. There's the 32 people that got raided last year, the year before, their campsites. And so every single time, I just want to end on this math from my personal statement. I have seen nobody want to address the elephant in the room, which is that there will almost always be more people than there are shelter beds. And if you expect us to abide by your codes, to sleep by your 300 rule code, your rental codes, you have to go into a shelter if you plan on staying inside this city, your codes are mathematically jacked. And, I cannot wait until we get hold of more homeless people to trade stats with. We have a pretty formidable fight going for it. So, but yeah, no objections to me sleeping. Like I said, though, I am pretty disappointed, though, in that they jumped straight to the conclusion, thought we were camping, and then actually woke us up. And at that point, I can 100% guarantee you, I did not get anything worth of a habitation-type sleep for that evening. I had a 2-hour nap. Thank you.
All right, questions?
Just a couple of questions. You testified that, just to clarify this. So from your testimony, you ended up in a homeless situation, not 6 years ago, so basically the spring of 2015, is that?
Yes, that's correct.
Around there. And then you did try the shelters in June or July.
Yes.
And then you tried so at that point you did try the shelters again, I assume.
No. And also too, the 3 months, were far past that point of being homeless, by the time we got this ticket. So there's no residency that we could have gotten. It would have had to be the random raffle each night for the shelter. And so we actually, if I recall going back, I think there was once that we went back and could get a bed anyways. So
And that was after the June or July thing, or something? Did you say?
I recall,
Or
I
was
think,
that around?
after the 2 incidences that we did get to the shelter. So there was, if I recall, another incident where, I don't know if Dave was with me, but I checked.
Okay. So there was one time after the June or July that you checked
Yes.
the shelter, and after that, that you didn't go back and check again, is that?
No.
Just sorry.
We do oftentimes talk to homeless people, and more often than not, when the topic of beds comes up, the shelter beds always fill up every night, and there's always people turned away. And so when we take that into account, we don't really bother anymore.
And so in this incident, assume you normally sleep more than 2 hours a day.
It would be nice to.
Well, on an average, are you indicating that you only can sleep 2 hours a day?
Oh no, I
On this day because they interrupted your day.
Well, in general, about 8 hours is what I find I require.
Okay.
So 5.5 at the shelter, for instance, is not enough in the first place.
And so you do get sleep. In this case, I understand on this date you weren't able to do that because you got woken up.
Yes.
All right. But normally you sleep, and at what point did you, now you're in your van, I guess, that you indicated in your testimony.
Sure. Yeah.
Right. And so now,
come find me.
Yeah, I'm not trying. That's not the purpose of that. So at this point, you had a period of months before you started using the van that you were homeless?
Oh yes, the van only came in October or November. Literally, my brother and I had to basically rekindle the estranged relationship with our father. We needed a place to sleep because we were literally followed by police after our Northern College Gustav Swanson ticket.
All right, so you had about a 6-month period, I guess, before you got the van,
Yeah.
where basically you had no place to stay, the shelters didn't work out,
Yep.
and you basically resided in Fort Collins, but not in a home.
Exactly.
All right, thank you.
Anything you want to add to your testimony? Just personally, I've met enough people now that the stats are just
really awful. For example, Thomas Maldonado, someone I met, I have to testify that I met him. He said that he did not receive a camping ticket when he was arrested off of a warrant that was found. I also have another friend, I don't recall his name, but he's an older gentleman, and trying to identify with the shelters. He was issued a camping ticket, he told me, for simply putting his head on a backpack in the middle of the day in the park, and he had explained that was Mike West that had taken him there. So I'm just, from my experiences, people have told me that this camping ordinance has been inconsistently applied.
Okay. And did you have any other evidence to present?
Oh yes, yeah. Do I do it during witness statement, I guess?
If you're done with your testimony, if you have any exhibits or anything else that you wanted to offer, this would be the time
yes,
to do it.
Absolutely. Okay, so it's very basic. There's 3 news articles. One's from September 24th, 2014. That's Exhibit B. One's from 31st of March, 2015. That's A. And one's from March 3rd, 2016. That's C. And they're just newspaper articles.
Proof, what do they indicate?
Yes, so the title of Exhibit A, Fort Collins homeless shelter beds back down for spring. Basically March 31st of last year, only a couple months before we were ticketed. They basically went over the stats of the current homeless population in the city and basically said that there are 301 people, and so forth and so on.
This is really like hearsay,
Yeah.
and I don't really. In this case, to
Are these-
present a newspaper article, I mean, we don't.
These all articles from the local paper?
Yeah, from the local Fort Collins, Colorado.
Okay. Why don't you go ahead and have the officer show those to the prosecutor and see if he's objecting to all 3 of them. So they're all 3 articles out of the local paper relating to the homelessness or camping issues?
Yeah, and specifically
Shelters.
to the shelter bed that's available. Excuse me.
I don't have an objection. I'm not really sure how relevant it is, but I guess we'll leave it up to the judge whether you want to considering those relevancies.
So you want to agree to allow them to be admitted?
At least for that purposes, like I said,
Okay.
I'd argue they're not. I'm not sure what the relevancy is, but I don't have an objection.
So the Exhibit A is talking about the number of shelter beds being lower during spring, summer months. Is that what you're indicating? And then Exhibit B.
Was an older article from last year saying that it was still a problem then, and then the 3rd article is saying that it's actually gotten worse since last year.
And that's from March of this year. Okay. So A and C are almost a year apart.
Yeah. And so I can elaborate on the relevance.
Okay, go ahead.
So those being the articles, I found a very interesting study done by the University of Denver. Sturm College of Law. This is their homeless advocacy policy project. If a while wants to see this, basically this kind of summarizes what those articles do. And basically, it was a scientific study that found out that there's at any given time more people in shelter bed, or more people than there are shelter beds, and that over the last couple of years, tickets have gone up, significantly, faster than beds can accommodate for. And then, of course, the whole reason I'm trying to get to this, I totally understand the appeal procedure and so forth, and my rights to an appeal, maybe saving this argument for an appeal, but lo and behold, if anybody hasn't read it, here's the Boise, Idaho Statement of Interest, which was very, 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 very easy to read, very specific, and in a nutshell, it said that shelter beds, if they are...
At this point, it's good with regards to a case that's not from our jurisdiction.
It's a Supreme Court, so...
But it's a letter
That's a legal argument, I think, basically, at this point.
Yeah.
But
from the Department of Justice.
It's not obviously our statute hasn't been declared unconstitutional, and so, that might be something for a legal argument, but to try to present it as evidence this needs promoting.
I would agree. So it would not be, it's something that we would admit as evidence.
Yeah, I have a feeling. I know that you guys have your little, I don't know how to call it, just your municipal tickets. You know, am I sleeping? Yes. Now I go fight it in a real court. The reason why I wanted to admit it was if you were to read this and then base your information off of this and that, I don't know if you'd be doing the job of the appeal judge, but technically I imagined that you would be able to come to the same conclusion that what I'm advocating is cruel and unusual punishment. The shelter beds are too full. In my personal experience, they've never offered more than 5.5 hours of sleep, and I don't want to call it a disability, but I tried to sleep at that level before for those 3 months in the last 6 years. I couldn't do it, and so the number one reason that the Boise, Idaho had got overturned was because there were shelter beds. If there weren't, okay, how to put this, if they didn't accommodate everybody, including disabilities, that it was deemed cruel and unusual punishment to be issued camping tickets. And so my disability has been longer-term homelessness than what the shelters can provide, and as such, I think this is really cruel and unusual punishment.
All right, and you're getting into your closing argument at this point. Did you have any other evidence to present?
Let's see here. Well, I will definitely say, without a doubt, David and I picked up our stuff every morning and returned. I mean, it didn't matter if we returned somewhere else or there. It was all the same place in the city, We actually looked into the KOA. It was about $48 a night for 4 whole spots. Everything else requires an RV. We always liked or try to quote unquote sleep or camp near amenities, because that's obviously one of the contentions with camping. There was obviously a very close bathroom available. We don't like to damage property. Obviously there was dirt we put our air mattresses on. And then to finish up, I don't know what sort of special agency tribunals one can do, but I'm starting to wonder how you guys can be so affiliated with other institutions, like representing the Catholic Charities and so forth, for their stats, but not have any actual legal affiliation to them. So I would be curious to see how the special agency tribunals are to go. Other than that, I can definitely tell you guys, I was not habitating it for the purposes of habitating it. You, as a city, with your employees and your lack of child protective services, your failed judge and so forth, literally gave me no other choice. Also being assaulted out of my residence, losing my job at the same time. Kind of need a place to sleep, and I really don't think it's very intellectually honest to expect people that can't make it into the shelters every night to leave the town every night to sleep. I think that's preposterous. But other than that, this will all be in some really big, fantastic counter complaint. I'll save the words for that.
All right, so you can go ahead and have a seat. And did you have any other witnesses or evidence to present, Mr. Montgomery?
I don't believe so. No, Your Honor.
Any rebuttal?
No, Your
All right, closing argument, city first.
Honor. The defendant's charged under the camping ordinance, and at this point, the ordinance has not been declared unconstitutional in the case, and so the issue here basically is whether it meets the elements of camping or meets the elements of incidental mapping. And I would argue, in this case, the defendant's testimony really, in this is, he's been honest, he has been getting away from the period, obviously prior to that, to the earlier things here. Basically in the spring of last year, he became homeless again, he and his brother. And we had a period from including this date, from spring of last year until the October, probably, I think is what he said, when they were able to get the van, that basically, other than trying to use the shelters, I can't remember how, he said 1 or 2 days, I can't remember specifically when he tried to use the shelter on that. And basically, really what they've been doing is they've been camping in the city every day since they became homeless. The statistics about the shelter and whether the shelters have space available or not, in this case, that would be relevant if the defendant was turned away from the shelter. But in this case, the defendant, as he admitted himself, tried the shelter in June or July, and then I believe came back at one point again. And he recalled at one point trying to come back, and I think tried to get in one time and didn't get in because of the lottery. On this particular incident, on September 8th, the defendant indicated that he had been sleeping for 2 hours, and at that point, basically, the police officers contacted him. He would have slept longer, but obviously the police officers woke him up there, and so he ended up with a 2-hour.
Okay, I think you can go ahead now.
And so what the defendants testified is that he needs 8 hours of sleep a night, and that's the problem. One of the problems with the shelters is that he couldn't get enough sleep for that, and that he basically did not have a resident that whole time, and in fact was sleeping, as he put it, sleeping in the city for 8 hours a day, which in this case constitutes camping, and it certainly does not constitute incidental napping. And the officers probably explained incidental napping best, and when they were asked about what they would consider incidental napping, they said, obviously, if somebody lays out a blanket in the park and they want to take a little nap there, that's certainly when somebody wants to do the incidental napping. Bar could be the incidental napping. You don't bring a tarp, you don't bring a air mattress, you don't bring a sleeping bag, you don't set up that elaboration thing, and then take an incidental nap. We do know that the defendant's campsite was there for previous things. We don't have evidence that to contradict the defendant picking it up every day, although the officer's testimony was that when he returned to the campsite, it appeared that everything was in the same place. Well, whether they picked up, you can't camp for 8 hours a night, pick up your items, go back, camp again for another 8 hours a night, and then argue that it's incidental napping when it comes to whether the defendant is in violation of the statute. What the statute itself basically is, it doesn't allow them to sleep, spend the night, or reside or temporarily dwell with or without bedding, with or without shelter, or to conduct daily living activities such as eating or sleeping. And this is, in fact, the daily activity of sleeping is what, in fact, the defendants did from the May or whatever in the spring when they lost the housing that they had until the time that they got the van. That's basically what they were doing, is conducting the daily activities of sleeping every day. Because the defendant certainly didn't say I was up for 6 months without ever sleeping. So I would argue that our statute has not been declared unconstitutional, the camping statute. And until the defendant meets the elements of the camping statute and does not meet the elements of incidental napping in this case.
Great, thank you. Mr. Montgomery, this is your opportunity to make a brief closing argument as to why you think the charge has not been proven beyond a reasonable doubt.
Absolutely. So probably the number one thing that I noticed here was that nobody had any objection to the idea that a person who receives a camping ticket is more likely to be homeless versus someone who receives an incidental napping ticket or not, because they have a home. First off, real quick, to reiterate, you don't really know if they're incidentally napping to decide whether or not to issue them that ticket if you don't ask them. So if you just simply show up and write a ticket, that person has to come in and simply fight, well, I was incidentally napping. Like I said, that's still half my argument here, is that habitation requires being able to actually sleep. And so you guys sort of jumped the gun and, I feel like, issued a camping ticket before you had all the evidence. And but really, going back to what I was saying, it really, really, really concerns me that people that get a camping ticket are getting it because they have trouble being in a house. That means that some other financial reason as to why they're being ticketed. It's almost always not because they choose not to have a house. And so, because the tendency of people who get camping tickets to be of a certain demographic or national origin or anything that they have, that's the reason as to why they ended up in that boat. The 14th Amendment protects people against unequal application of the law, and there's a very important case that's been cited hundreds of times, Yipwo versus Hopkins, 1886. So that's 1886, basically, where they determined that while a statute may be, non-biased on its face, if it's ends up inadvertently being turning into unequal application through its application, then it's still deemed illegal. And so, while there's this, camping statute, and it's for anybody that happens to be sleeping, it ends up being for those that are obviously needing to habitate, because it's mutually exclusive. You're either incidentally napping and not habitating, or you are, incidentally napping and not habitating, or you're camping and you're habitating. And so, big violation of the 14th Amendment. Obviously, people who are homeless tend to get camping tickets more often than people that aren't homeless. That's kind of hard to describe. Find a better way to word this. You're not, because of the way it's even written and the way that it's mutually exclusive, either you're incidentally napping or you're having to camp, basically anybody that is needing to habitate, which by itself isn't illegal, just being awake in the town, all of a sudden, because they can't afford rent for their personal or national origin reasons, they cannot get into a place to stay that night. And so these are being, basically, they're nigger tickets. It's a disproportionately applied ticket that ends up only affecting a certain group of people. And while I know homeless people aren't a protected class or status yet, there are individuals that end up homeless through their national origin. Dave and I, one of them, were ex-Mormons. And so basically, the whole purpose of the ticket is actually inadvertently for you guys to ticket people's national origin, because the whole purpose is habitation. And when you draw the line on habitation, obviously this gets back to what I was saying. There's definitely never going to be enough bed space available compared to the people, unless that changes with some big shelter. And so the probability that someone is going to be outside at any given time is pretty high. And I just keep seeing people go back to, did I try the shelter beds that night? It might have been something he was alluding to, or something that I've been alluding to. But the whole point is that we shouldn't even be talking about the shelter beds. That's completely irrelevant information. It's a private entity. We have, as a city, or me personally, I have no control over their policies, what they do, how many beds they actually offer. And so, plus, I have personal reasons that I feel like I have a right to refuse that kind of service if it's an affiliated religious institution and I'm not of that religion. And so I respectfully, request the opportunity to not room and board with a private entity and have that be in lieu of being given tickets. It's a private entity. For all intents and purposes, there are no shelter beds available, and you're just issuing sleeping tickets to anybody that sleeps outside. And those that happen to sacrifice one right for the other, make it in bed, get the raffle. You're basically ticketing people who lost the raffle if they did go, or even if they didn't, other reasons, like disabilities and so forth. So it's just it's a really, 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 really slippery slope when you ticket somebody for a life-sustaining activity. You're guaranteed to get them for it. There's no victims, though. The city itself is kind of hard to call the city a victim. Like I said, there was no damage to any property. We left so that anybody else could use that area. If we're allowed to hang out and sleep with our eyes open by nudging each other for 8 hours, we're still allowed to hang out in that spot, technically for 8 hours, even with our air mattresses completely awake. So the only thing different is sleeping, and then so that leads into the whole, you get what you want, you get to move people around because everybody needs sleep. It's a pretty low blow, not you personally. I just have to, but basically though, tell me how many people that aren't homeless get camping tickets. That's kind of the unequal application of the law. And like I said, you don't even know that they're incidentally napping if you don't ask them. So how do you know that that person that you didn't ticket for incidentally napping was camping or not? They could have been camping and on a nice blanket, and you would never know because you assumed, based upon your experiences, that you must look like a yuppie, not a homeless man. And so that's kind of why I so adamant about this no probable cause is that, if you're using things like a sleeping bag that can absolutely be, air mattresses that can absolutely be information and investigation that can determine what we're doing. But if you don't even give yourself the due process, motion to suppress everything after that because, like I said, while I tried to camp, quote unquote, I'm not saying camp, I wasn't even given the opportunity. So, thanks for interrupting me. But it was a nice nap. I got about 2 hours in. And the officers, just to reiterate one last time, the officers definitely, if I recall, claimed that it is possible for someone to incidentally nap with an air mattress. And seeing as how I was interrupted, had to get my sleep elsewhere. Since I didn't have any other things that would determine a camping statute versus incidentally napping, like food preparation, fire, things like that, then you guys literally turned my camping ticket into an incidental napping ticket. Thank you. Good luck.
All right, thanks. Any final closing?
Just briefly on this, as the officers testified in this case, it's not looking at the person and deciding whether they are going to issue an incidental napping ticket or a camping ticket. In this case, the officers both testified they didn't know even who they were dealing with because if you look at the pictures, you can see in this case when they approach the defendants, they're completely covered up. If you look at those pictures, so it's not a question of. I'd argue it's not a question of who the person is and making the determination whether it's an incidental napping. On the other hand, the officers made the decision that it wasn't incidental napping and it was camping based on the material itself. And so in this case, what I would argue is if you are in the middle of City Park and you've set up what's in that picture, regardless of who you are, I mean, regardless of what the situation, what the person actually appears like, if you go to the park and set up that kind of situation with a tarp, with a air mattress, with a sleeping bag, that thing, it's hard to argue that that's incidental napping no matter who's underneath and who's not. And really what you have to look at is this situation, where they are, where the location where they were, Certainly not out underneath the tree in the middle of the city park taking a nap, but the setup that they had at that point, and as the officer said, they didn't even know, they couldn't tell who they were dealing with until they called them, called their names, and actually had the people come out and go out there. The alternative, I understand housing's a tough situation, there's not enough housing, but the alternative is not to let everybody camp wherever they want, because there's a housing shortage in Fort Collins. And the city's doing the best it can to try to accommodate people, buy shelters, buy programs, whether people take advantage of those programs or not. I would argue that needing to sleep 8 hours at night, and even if you can only get 5 hours of sleep a night, that is really, I don't think that meets the definition of disability. In this case, any of the arguments about whether shelter beds are available or not, the defendant, for whatever reason, he's chosen not to use the shelters, not that the shelters aren't available. So it isn't a situation where if he went every night and tried to get into the shelter, he couldn't get into the lottery, and for 6 months tried that every night and couldn't get in. That would be a different situation than this thing where he tried once or twice in a 6-month period. And otherwise just basically chose that they weren't going to use the shelter and were going to camp out, he and his brother, during that 6-month period. So again, I'd argue the fact that they interrupted him, whether they interrupted him only 2 hours of sleep or they interrupted him after 7 or 8 hours of sleep, it sort of clearly didn't meet the incidental napping, worst exception to the statute.
Okay, thank you. All right, well, I've already read that code section, 17-181 that we're dealing with here. So the defendant has asked us to look at the big picture issue, essentially, that this is a question about, one way to look at it is its appropriate or allowable use of public property or public lands. So the City of Fort Collins has adopted an ordinance in section 17-181 indicating that camping on public property is not allowed, and has some description of camping, and has this specific exception saying that camping does not include incidental napping or picnicking, to clearly indicate that those behaviors are allowed on the public property. The defendant has also argued in various ways that the ordinance or its application is unconstitutional. If you're arguing unconstitutionality, that argument has to be made beyond a reasonable doubt, and I'm going to find that the evidence does not indicate that the ordinance is unconstitutional. So looking at that ordinance, the question is, does the evidence in this particular case prove the charge against this defendant beyond a reasonable doubt? The testimony from the officers who were on scene that morning indicate this was about 9:30 in the morning. That first Ranger West and then Officer Haynes came upon this area, which was described as in the woods in an island, or apparently open area within a wooded area, why Ranger West referred to it as an island. That, as you can see from the photographs and from the testimony, there were tarps laid on the ground, then air mattresses, and then individuals covered up by sleeping rolls or blankets or in sleeping bags. Ranger West indicated he did not know who was in the camp. It appeared to be at least a couple of people covered up, that he felt he had probable cause to issue the camping tickets, and asked for backup and assistance from officers, and that decision was made based on the objective circumstances, including also bikes chained to the tree, which is shown in the photographs as well. And it was only after the officers arrived and they asked the people to wake up and approach them that then the individuals were identified. So it doesn't appear that there was any kind of selective enforcement or issue about determining who these folks were before deciding whether to issue the citations. So the officers, both Ranger West and Officer Haynes, testified that they did not believe that this was a situation of incidental napping, because in their experience, which for both of them is several decades, that incidental napping is more of something that is more commonly in open view in the park, either in the sun or the shade, possibly a blanket, but short time in duration. If you walk by, you see them resting, you come back by, they're gone, or sitting up, so it's a very short time period type of activity. In this case, because of all of the bedding and items used to create the beds, chained up bikes, they both felt that clearly this qualified as camping as opposed to incidental napping. Now, the defendant's argument is that you can't know which it is or unless you ask the person involved. So the defendant is arguing for more of a subjective choice or standard based on what the person's intention was. I think the ordinance refers more to an objective factual issue, a question of when you look at what you see there, all the circumstances. Does this look like sleeping, spending the night, residing or dwelling temporarily with or without bedding, etc., as opposed to incidental napping. Based on, and let me say one other thing, the evidence does not indicate either from the prosecution or the defense whether the shelters were full this morning or the night before. So I would agree that the shelter issue, which I think the defendant at one point said is really relevant, it is to this particular circumstance. So I am going to find, based on all the evidence, that the charge has been proven beyond a reasonable doubt, that with the setup that was involved here, the extensive amount of time it took to set it up, get in it, that even if it was only for a couple of hours, as the defendant says, that still constitutes a violation of Section 17-181 as camping as opposed to incidental napping. So in terms of finding the defendant guilty, we move on to the penalty. Does the city want to make an argument?
Your Honor, this is the defendant's, at least my aware, at least in our court, the first conviction for the defendant, and so I'd ask the court to basically treat that accordingly.
Okay. And I did say there's a petition approved earlier. Yes. Okay. All right. Well, I appreciate the circumstances that the defendant mentions, and so there's typically a $100 fine on a first offense. I'm going to suspend that without conditions, in part because of the circumstances, but also in part because this happened about 8 months ago, so it's already been quite a long period of time, and I think based on all the circumstances taken together, it's appropriate to suspend that with no conditions, and the costs are waived because of indigence. So it means that it is a misdemeanor conviction on the camping charge, but there is no financial penalty, no jail time that you need to pay or serve. So we want to move on to the next case.
Yes, Your Honor.
Why don't we take just a very short recess before we move on?
Right, thank you.
Good job, you got me this big crime.